Thank you, Counsel. Justice Thomas?
Did you have complaints that formed the basis of your concern about the fundraising activities here?
We certainly had complaints about crisis pregnancy centers that petition.
No, about this crisis pregnancy center.
So I think we've been clear from the outset that we haven't had complaints about this specific.
So you had no basis to think that they were deceiving any of their contributors?
I don't think that's correct, Your Honor. I think we had carefully canvassed all of the public information that is provided on the website of First Choice in making a determination that we wanted to initiate an investigation.
But you had no factual basis?
I don't think that's true, Your Honor. I think, for example, you could take a look at a comparison between the donation page for First Choice that we have carved out from the very beginning.
So you had no complainants?
Watch this moment, because what you just witnessed represents everything that is grotesque and broken about our captured judiciary. And understand that when you see Justice Clarence Thomas lean forward with that studied expression of prosecutorial rigor to demand whether the state of New Jersey had any complaints about this crisis pregnancy center before launching its investigation, you are watching theater of the most cynical kind, because this is a man who understands power and how to wield it for the benefit of the forces that have lavished him with luxury for decades. And what makes this moment so breathtakingly dangerous is not just Thomas interrogating a blue state attorney with that trademark aggressive minimalism, but the subtext screaming beneath every syllable, which is that the conservative supermajority on the highest court in the land is primed and ready to declare open season on any Democratic state that dares to investigate whether anti-abortion crisis pregnancy centers are deceiving vulnerable people at the exact moment when those centers have become the shock troops of the post-Dobbs reproductive surveillance state. A majority of the Supreme Court appeared skeptical Tuesday of New Jersey's effort to subpoena donor information from crisis pregnancy centers without federal court review, and Justice Clarence Thomas repeatedly pressed New Jersey's attorney to explain why the state targeted the religious centers in the first place, designed to get New Jersey to acknowledge the state had not received specific complaints about First Choice. Let that sink in, because what Thomas is doing here with surgical precision is constructing a narrative framework that positions state consumer protection investigations as inherently suspect fishing expeditions when they target anti-abortion organizations, and this comes at the exact moment when nearly $430 million in federal funding went to crisis pregnancy centers over the last 5 years, with nearly $430 million going to more than 650 CPCs in 49 states between 2017-2023, and when as of last year, there were more than 2,600 crisis pregnancy centers and only 765 abortion clinics in communities across the U.S., with the crisis pregnancy center industry expected to bring in more than $2.5 billion this year. This is a multi-billion-dollar ideologically driven apparatus masquerading as healthcare, and Thomas wants you to believe that investigating it without a specific complaint is governmental overreach. But here is where the intellectual dishonesty becomes almost suffocating, because New Jersey Attorney General Matthew Platkin, a Democrat, subpoenaed the centers in 2023 as part of an investigation into whether the nonprofit violated consumer fraud laws, because state officials said their marketing may have left some patients with the impression that they could receive abortions at the facilities, and the entire premise of consumer protection law is that states have the authority and indeed the obligation to investigate patterns of deceptive advertising before specific complaints pile up, because waiting for complaints means waiting for harm. This is Regulatory 101, and Thomas knows it, but watch how he hammers away at this attorney with question after question about the absence of complaints, as if the only legitimate basis for investigating potential consumer fraud is after victims have already been deceived, already been harmed, already been stripped of their reproductive autonomy. Through delay tactics and misinformation, what you are witnessing is the methodical construction of a legal doctrine that would handcuff blue states from proactively protecting their residents from organizations that the medical establishment has overwhelmingly condemned as unethical. And speaking of ethics, let us be exquisitely clear about who is sitting in judgment here, because for over 20 years, Supreme Court Justice Clarence Thomas has been treated to luxury vacations by billionaire Republican donor Harlan Crow, and ProPublica documented an array of undisclosed luxury vacations and other gifts Thomas has received over the years from several billionaires, including Crow, who treated Thomas to numerous private jet flights and international yacht cruises, covered private school tuition for Thomas's relative, and paid Thomas money in an undisclosed 2014 real estate deal, and the Senate Judiciary Committee found nearly $4.2 million in gifts with at least 3 additional trips Thomas failed to disclose. This is the Justice lecturing a state attorney general about investigative standards while he himself has violated disclosure laws for decades and accepted hundreds of thousands if not millions of dollars in unreported gifts from conservative megadonors whose entire political project is remaking the judiciary to serve corporate and religious conservative interests, including the systematic dismantling of reproductive rights. The hypocrisy would be comedic if it were not so devastatingly consequential, because crisis pregnancy centers are not benign counseling services offering neutral information. They are ideologically driven organizations whose explicit mission is to prevent abortions by any means necessary, and the evidence of their deceptive practices is overwhelming. 30% of CPC websites promoted abortion pill reversal, with some centers directly targeting women who might regret starting a medication abortion, and this treatment lacks FDA approval and could increase the risk of serious complications like sepsis. 65 CPCs made inaccurate or inflammatory statements about pregnancy or abortion. In just one state study, CPCs not only misrepresent the health risks of abortion, but also may intentionally lie to their clients by reporting incorrect gestational ages of their pregnancies, forcing an increase in second trimester abortions, or preventing patients from accessing abortion altogether. This is not healthcare. This is ideological manipulation, dressed up in medical theater, and Thomas wants to protect it from state oversight. What makes this Supreme Court argument particularly chilling is the timing, because the facilities known as crisis pregnancy centers have been on the rise in the U.S., especially since the Supreme Court overturned abortion as a nationwide right in 2022, and most Republican-controlled states have since started enforcing bans or restrictions on abortion, with some steering tax dollars to the centers, which means we are watching the construction of a parallel anti-abortion infrastructure that increasingly operates as the only option available to pregnant people in red states, while simultaneously metastasizing into blue states, where they use deceptive advertising and search engine optimization to misdirect people seeking abortion care, and Thomas is positioning the court to shield this entire apparatus from democratic accountability. Many Democratic-aligned states have sought to protect abortion access, and some have investigated whether pregnancy centers mislead women into thinking they offer abortions, and that is precisely what Thomas and the conservative majority appear poised to stop. And let us talk about what these centers actually do on the ground, because this is not abstract legal theory, this is about real people facing real coercion at vulnerable moments. 71% of CPCs use deceptive means such as spreading thoroughly debunked misinformation, and 38% do not clearly state on their homepage that they do not provide abortion care, and by using deception, delay tactics, and disinformation, CPC staffs undermine the tenets of informed consent and patient autonomy. And there's a fair amount of evidence that anti-abortion crisis pregnancy centers are collecting information about people and creating a mass database of young pregnant women, raising concerns that CPCs are actually surveilling women for criminal prosecution. This is surveillance masquerading as support, and Thomas, with his decades of acceptance of luxury gifts from conservative megadonors and his wife's well-documented involvement in efforts to overturn the 2020 election, is sitting on that bench protecting these organizations from investigation. Oral argument itself reveals the ideological project at work here, because Thomas is not engaging in neutral statutory interpretation. He is constructing a permission structure for the conservative majority to rule that states cannot investigate anti-abortion organizations without meeting heightened standards that would be absurd in any other consumer protection context. The appeal filed by the centers touches on federal courts' power to review state subpoenas at an early stage, particularly when they might involve First Amendment violations, with First Choice saying there's no question that their First Amendment interests are arguably burdened by the subpoena, which sets up the court to potentially establish a new doctrine that religious anti-abortion organizations enjoy special First Amendment protections against state consumer fraud investigations. This would be a catastrophic expansion of religious exemptions from generally applicable laws, and it would essentially immunize crisis pregnancy centers from the kind of oversight that every other business providing services to vulnerable consumers must undergo. The broader context makes this even more urgent, because several conservative state governments have in recent years passed new legislation and increased financial support for anti-abortion centers, with taxpayer funding for anti-abortion centers increasing dramatically after 2022 in states where abortion is now severely restricted, including Florida increasing spending from $4.5 million in 2022 to $25 million in 2023, and Tennessee increasing from roughly $3 million to $20 million. which means red states are actively subsidizing these organizations with massive public funding, while blue states that try to investigate whether those same organizations are engaging in consumer fraud face potential Supreme Court rulings that could tie their hands. This is minority rule weaponized through the judiciary, and Thomas, who has benefited from the largesse of conservative billionaires for decades, is the tip of the spear. What you need to understand about this case is that it represents a microcosm of the larger authoritarian project being executed through the federal judiciary, which is to systematically dismantle the regulatory and investigative capacity of democratically elected state governments when those governments try to protect their residents from right-wing ideological organizations. The conservative legal movement has spent 50 years building towards this moment where they control the Supreme Court with a supermajority immune to democratic accountability, and Thomas, who was confirmed by the narrowest margin in a century after credible allegations of sexual harassment, is now the longest-serving justice using his position to advance an agenda that benefits exactly the kind of billionaire donors who have showered him with gifts. Thomas's decisions have been benefiting wealthy and powerful political donors like Harlan Crow for decades, as he has ruled against donor disclosure and against having any contribution limits at all. And even if Thomas hasn't specifically benefited Crow through his decisions, he has undeniably helped to make mega donors like Crow more powerful and more insulated from public criticism. The oral argument strategy here is also revealing because Thomas is doing what conservative justices have perfected, which is using facially neutral procedural questions to smuggle in substantive ideological outcomes, and by hammering the New Jersey attorney on the absence of specific complaints, Thomas is setting up a framework where any state investigation of conservative organizations can be characterized as politically motivated harassment rather than legitimate consumer protection enforcement. The lower court decisions would mean that the NAACP could have received a hostile subpoena from an attorney general, and federal court review would not have been available until a state court ordered enforcement, argued the attorney for the crisis pregnancy centers invoking civil rights history to protect anti-abortion organizations from oversight, which is the kind of rhetorical judo that conservative lawyers excel at, taking the language of civil rights and deploying it to shield religious conservative organizations from democratic accountability. And we need to be absolutely clear about what is at stake, because crisis pregnancy centers violate ethical principles by providing misleading information and causing delays and inequities in access to abortion, and TSPCs are nonprofit organizations that present themselves as healthcare clinics while providing counseling explicitly intended to discourage and limit access to abortion, engage in purposefully manipulative and deceptive practices that spread misinformation on sexual health and abortion, and have been shown to delay access to medically legitimate prenatal and abortion care, which negatively impacts maternal health, and the American College of Obstetricians and Gynecologists and other major medical organizations have condemned these practices as unethical. This is not a close call from a medical ethics perspective, but Thomas wants to constitutionalize protection for these organizations and prevent states from investigating them. The deeper constitutional question here is about federalism and state sovereignty, because if the Supreme Court rules for the crisis pregnancy centers, it will be establishing that federal courts can intervene at the earliest stages of state consumer protection investigations when religious organizations claim First Amendment burdens, which would be a radical expansion of federal judicial power over state regulatory authority. If the Supreme Court sides with First Choice, it would open the federal courts to a flood of litigation challenging myriad state and local subpoenas, and First Choice said access to federal court is important in cases where government investigators are accused of misusing investigative power, but this is a feature, not a bug, for the conservative legal movement, which wants to flood federal courts with challenges to state progressive policies and use the conservative federal judiciary as a veto point against democratic state governments. And let us not forget the personal dimension here, because Justice Thomas has demonstrated through his decades of undisclosed gift-taking that he holds the ethical rules that govern other federal officials in contempt. His failure to report the flights appears to violate a law passed after Watergate that requires justices to disclose most gifts, and the undisclosed gifts to Thomas have no known precedent in the modern history of the Supreme Court. Even after new amendments, there are many gifts Thomas received that he has still not disclosed, including a 2019 trip to Indonesia on Crow's private jet for an extended island cruise that could have cost more than $500,000, with 7 ethics law experts saying Thomas appeared to have violated federal law by failing to disclose the free travel. This is the justice who thinks he has the moral authority to lecture state attorneys general about investigative standards when he himself has flouted disclosure requirements for decades. The question of complaints versus proactive investigation is also a red herring, because consumer protections law has always recognized that regulators need not wait for victim complaints before investigating patterns of potentially deceptive conduct, and indeed many of the most vulnerable consumers never file complaints either because they do not realize they have been deceived or because they lack the resources and knowledge to navigate complaint systems. By demanding that New Jersey identify specific complaints about First Choice before initiating an investigation, Thomas is essentially requiring states to allow harm to occur before they can act, which inverts the entire purpose of consumer protection regulation and sets up a standard that would cripple state enforcement across the board. Imagine telling a state attorney general they cannot investigate a pattern of potentially fraudulent mortgage lending until after homeowners have already lost their houses, or that they cannot probe potentially deceptive pharmaceutical marketing until after patients have suffered adverse events. This is not how regulatory law works, and Thomas knows it, but he is constructing this evidentiary burden specifically to protect religious conservative organizations from oversight. The fact that this case involves donor lists also reveals the cynical strategic thinking at work, because that line of questioning was designed to get New Jersey to acknowledge the state had not received specific complaints about First Choice. And the subpoena for donor information allows the crisis pregnancy centers to claim that the investigation will chill First Amendment-protected associational rights, which brings in decades of Supreme Court doctrine about protecting political associations from state harassment. But the comparison to civil rights organizations facing hostile Southern state governments in the 1950s and 60s is obscene because crisis pregnancy centers in 2025 are well-funded, ideologically driven organizations that receive massive public subsidies and operate in a political environment where they have the full support of the Republican Party and conservative movement infrastructure. They are not vulnerable minorities facing state persecution, they are powerful institutions seeking immunity from consumer protection oversight, and Thomas is helping them construct that immunity. The emerging doctrine from this court on religious liberty and free speech has become a permission structure for conservative organizations to claim exemptions from generally applicable laws, and this case fits perfectly into that pattern, because if the court rules for First Choice, it will establish that state consumer protection investigations of religious anti-abortion organizations trigger heightened First Amendment scrutiny, requiring states to demonstrate specific evidence of harm before they can even issue investigative subpoenas. This would be a radical departure from standard administrative law, where investigative authority is presumptively valid and regulated entities must comply with reasonable information requests as part of the investigative process. But Thomas and the conservative majority are systematically rewriting administrative law to constrain the regulatory state when it comes to industries and organizations aligned with conservative political priorities, and the media coverage of this oral argument has been frustratingly both sides is treating this as a neutral legal dispute about federal court jurisdiction rather than what it actually is, which is a conservative supermajority positioning itself to shield anti-abortion organizations from democratic accountability at precisely the moment when those organizations have become the enforcement arm of the post-Roe anti-abortion regime. The Supreme Court seemed likely on Tuesday to side with a faith-based pregnancy center raising First Amendment concerns about an investigation, and a majority of the justices seemed to agree that they should be able to challenge the subpoena in federal court, which means this is almost certainly going to result in a ruling that expands religious organizations' ability to resist state investigations, and the implications for state regulatory authority across issue areas will be profound. What makes this moment so infuriating is that we are living through the consequences of a 50-year conservative project to capture the federal judiciary, and the Supreme Court in particular, and now that project is bearing fruit with case after case dismantling the regulatory state, advancing religious conservative social policy, and constraining the ability of democratically elected governments to protect their residents. Thomas, who was placed on the court specifically to advance this agenda, has been rewarded with luxury vacations and gifts worth millions of dollars from the very conservative donors whose ideological infrastructure includes funding and supporting crisis pregnancy centers, and now he sits in judgment on whether states can investigate those organizations. The corruption is structural, and it is brazen, and the fact that Thomas faces no meaningful accountability for his decades of ethics violations demonstrates how thoroughly this court has insulated itself from democratic oversight. The only path forward requires democratic mobilization, institutional reform, because the Supreme Court as currently constituted is a counter-majoritarian institution advancing a minority agenda, and the only way to check its power is through political action that expands the court reins in its jurisdiction and establishes enforceable ethics requirements. The Thomas revelations helped plunge the Supreme Court into its biggest ethical crisis in the modern era, and in response the court last year adopted a code of conduct for the first time in its history, but that code has no enforcement mechanism, and Thomas continues to issue rulings in cases involving the very interests that have showered him with gifts. The public approval of the court has collapsed because people understand that it is no longer functioning as a neutral arbiter of constitutional law, but rather as a partisan institution advancing conservative political priorities. When you watch that clip of Thomas aggressively questioning the New Jersey attorney, understand that you are watching the operation of minority rule through an unaccountable judiciary, and the specific issue of crisis pregnancy centers is just one front in a much larger war over whether democratic governments will have the authority to regulate powerful institutions, or whether those institutions will claim constitutional immunity based on religious liberty and free speech. The crisis pregnancy center industry represents everything that is broken about post-Roe America, where ideologically driven organizations masquerade as healthcare providers, receive massive public subsidies, engage in systematic deception, and then claim First Amendment protection when states try to investigate them, and Thomas, who has shown nothing but contempt for ethical rules, who has accepted millions in undisclosed gifts from conservative billionaires, who has ruled consistently to benefit the wealthy and powerful, is the perfect avatar for this court and this moment. The historical parallel here is to the Lochner era, when a conservative Supreme Court struck down progressive state labor regulations in the name of constitutional liberty, and it took the political mobilization of the New Deal and the threat of court packing to finally break that court's stranglehold on democratic reform. We are living through a new Lochner era, where the conservative supermajority is systematically dismantling the regulatory state and constraining democratic governance in the name of religious liberty, free speech, and other constitutional doctrines that have been weaponized to serve conservative ends. The crisis pregnancy center case is just the latest example, and unless there is sustained political pressure and institutional reform, the outcomes will only get worse. This court needs to be expanded, its jurisdiction needs to be limited, and enforceable ethics rules need to be imposed, because otherwise we will continue to see justices like Thomas, who owe their lifestyles to conservative billionaires, issuing rulings that protect conservative institutions from democratic accountability. The stakes could not be higher, and the urgency could not be greater, because every day this court operates with its current composition and its current lack of accountability is another day that minority rule through the judiciary becomes more entrenched.